The gate went up on a Thursday. No warning, no negotiation. Just a steel farm gate across the only road into a 140-home neighborhood, and a sign with one name on it. Mine. I'm a retired land surveyor, 38 years. When I inherited my father's ranch, I did what surveyors do. I opened the filing cabinet. The bridge was in the first folder. My father built it in 1967. The second folder was labeled Developer Correspondence, 1993 to 1995. Inside was a letter my father wrote in June 1994. He gave the developer temporary construction access. He typed, in plain language, "This does not constitute an easement. Permanent residential access requires a separate recorded instrument." The developer sold 140 lots and never came back. The county road department told the HOA in 2003, 2011, and 2019 that the bridge was private property. The HOA filed the letters and kept driving. The judge was a former title examiner. She read my father's letter on a Thursday morning. The gate locked that afternoon. All right, starting from the beginning. Before we go any further, let me know where you're listening from today, and be sure to like and subscribe. Walter Marsh had never intended to look closely at the bridge. He had crossed it 100 times as a boy. The concrete span over Sutter Creek, 12 feet wide and 40 feet long. The guardrails his father had formed from salvaged pipe fencing. The creek running 6 feet below the deck in spring and dropping to a trickle by August. His father had built it in the summer of 1967 with a contractor from the county seat and 2 hired hands. The construction taking 3 weeks. The concrete poured in 2 lifts. The whole project documented in a manila folder his father had kept in the ranch office's filing cabinet, under the tab marked Bridge, Sutter Creek, 1967. Walter had seen the folder as a child and had not thought about it again for 50 years. He had thought about a great many other things in those 50 years. A civil engineering degree at the state university, a surveying license at 31, the examination passed on the first attempt. 38 years of survey and engineering work, boundary disputes, subdivision plats, drainage studies, road alignments, the full spectrum of work that the intersection of land and law produces in a rural county, where property lines matter and deed records are the authoritative text. He had retired at 68 with a client list he had handed to his junior partner, and a reputation built on the specific quality that made surveyors valuable in disputed situations. He read the instruments with complete fidelity to what they said, rather than what the parties wanted them to say. His father had died in January 2021. 91 years old, the ranch still running at reduced scale, the cattle herd smaller than it had been in the 1980s, but the land intact. The estate had passed to Walter as the sole heir, the probate straightforward, the deed transfer recorded at the county clerk's office in March 2021. Walter had driven to the ranch the week after the deed recorded, and had walked every boundary of the 340-acre parcel for the first time in 15 years. Not an inspection exactly, but the particular kind of attention a surveyor pays to land that has become his, the habit of professional observation applied to personal property. He had stood on the bridge on that March walk and had looked at the concrete deck, the surface weathered and cracked at the expansion joints, the guardrail pipes showing rust at the base plates, the concrete abutments sound but stained from 30 years of seasonal flooding. He had looked at the neighborhood on the far side of the creek, Crestwood Meadows, the 140-house subdivision that had gone in on the downstream acreage in the mid-1990s, the development's entry road running directly to the bridge's eastern approach and crossing to the county road on the western side. Every car that entered or exited Crestwood Meadows crossed this bridge. Every school bus, every delivery truck, every emergency vehicle. The bridge was the neighborhood's single vehicle connection to the county road system. He had stood on the deck and had done what a surveyor does when standing on a structure whose legal status is not immediately clear to him. He had tried to remember what instrument established the right to be there. He could not remember one. He had walked back to the ranch house and had gone to his father's filing cabinet. The folder marked Bridge, Sutter CRK, 1967, had been where he remembered it. Inside, the construction contract with the county contractor, the materials invoices, a hand-drawn cross-section sketch his father had made before the pour, and the deed description of the parcel on which the bridge sat. The bridge was on parcel 44-3301-002. the Marsh family parcel, the 340 acres. The construction contract named Harold Marsh as the owner. There was no easement document in the folder, no right-of-way instrument, no recorded access agreement of any kind. He had pulled the county assessor's parcel map from the filing cabinet's bottom drawer. His father had kept a copy, updated in pencil each time the neighboring parcels had changed hands, and had traced the bridge's location against the parcel boundary. The bridge's western abutment sat 40 feet inside the Marsh property line. The bridge's eastern abutment sat at the edge of the parcel, the creek's eastern bank approximately where the subdivision's road began. The entire bridge structure, both abutments, the full span, the approach on the western side, was on Marsh family land. He had called Margaret Solis the following Monday. Margaret had been in practice for 31 years. Real property, title disputes, quiet title actions, easement litigation, the work that property law produces in counties where land has been passing through families for generations, and the instrument record is occasionally less complete than it should be. She had handled Walter's father's estate planning documents in 2018, and had met Walter twice in that context, enough to know he was precise, unhurried, and did not call attorneys unless he had already read the relevant documents and formed a preliminary conclusion. He had brought the 1967 folder and the parcel map to her office and had laid them on her conference table without preamble. He had said, "The bridge is on my property. I can't find any easement instrument. I'd like to know what the county deed records show before I draw any conclusions." She had said, "I'll pull the full title chain and call you." The title chain search had taken 4 days. She had pulled every recorded instrument affecting parcel 44-3301-002 from the county deed records, going back to the original government patent, the full ownership history, the liens, the easements, the right-of-way dedications, every instrument that touched the parcel. She had then pulled the Crestwood Meadows subdivision plat, and every recorded instrument in the chain of title for the subdivision's common area parcels, including the access road parcel that connected the subdivision's interior road network to the bridge's eastern approach. She had called Walter on Friday afternoon and had said, "Come in Monday, bring the folder." The title chain showed what the 1967 folder had suggested. Harold Marsh had acquired parcel 44-3301-002 by warranty deed in 1951, the parcel including the full Sutter Creek corridor, both banks, and the bridge approach on the western side. The bridge had been constructed in 1967 on that parcel, with no conveyance of any interest to any other party. No easement had ever been recorded against parcel 44-3301-002 in favor of any neighboring parcel, the county, or any other entity. No right-of-way dedication had been filed with the county road department, affecting the bridge or the western approach road. The county deed records showed the bridge as private property in continuous Marsh family ownership from 1967 to the date of Walter's deed transfer in March 2021. The Crestwood Meadows subdivision plat, filed in 1994, showed the bridge as the subdivision's primary vehicle entry point. The plat's legend identified the bridge approach road as the subdivision's main access corridor. The plat's notes section contained no reference to an easement, a right-of-way instrument, or any recorded access agreement with the Marsh family. The subdivision had been platted with the bridge shown as the entry point, and no instrument establishing the legal right to use it. Margaret had set the title chain summary on the conference table beside Walter's folder, and had said, "The developer's title search in 1994 either missed the bridge's private ownership status or identified it and proceeded without securing the easement instrument. Either way, the subdivision was platted and built without a recorded right-of-way across your father's property. There is no prescriptive easement claim that survives scrutiny. We'll address that when we get to the legal analysis. But on the instrument record, the position is unambiguous. The HOA has no recorded right to use that bridge." Walter had said, "I want a licensed survey confirming the bridge's location relative to the parcel boundary before we proceed." She had said, "Commission it. I'll wait for the survey before I prepare the demand letter." He had commissioned the survey himself, the work he had spent 38 years doing, now directed at his own property. The professional detachment of a surveyor applied to a situation with personal stakes. He had set the corner monuments, run the boundary traverse, located the bridge abutments relative to the property line, and produced a survey plat that documented in licensed professional form what the deed records and the 1967 folder had indicated. Both abutments, the full deck, and the 40-foot western approach road were entirely within parcel 44-3301-002. The nearest property line to the bridge's eastern abutment was the Sutter Creek eastern bank, the boundary between the marsh parcel and the subdivision's road parcel, which fell 2 feet east of the abutment's face. The bridge ended on marshland. The subdivision's road began where marshland ended. He had filed the survey plat with the county surveyor's office and had sent Margaret a copy with a one-line note. Survey confirms. Bridge entirely on marsh parcel. Both abutments, full span, western approach. Margaret had received the survey on a Tuesday and had added it to the file. She had then turned to the prescriptive easement question, the argument the HOA would inevitably raise when the demand letter arrived. The claim that 28 years of continuous, open, uninterrupted use of the bridge had produced a prescriptive easement by operation of law. The prescriptive easement doctrine required 4 elements in this state: open use, continuous use, use for the statutory period, 20 years, and hostile use. The hostility element was the decisive one. Use was hostile when it occurred without the owner's permission, in a manner adverse to the owner's interest. Use that was permissive, use the owner had allowed, expressly or by clear implication, could not be hostile, and non-hostile use could not ripen into a prescriptive easement, no matter how long it continued. Margaret had examined the 28-year use history with the hostility element in mind. The developer's construction crews had begun using the bridge in 1994, during the subdivision's construction phase. The first residents had moved in during 1995. The use had been continuous and open, 140 households crossing the bridge daily for 28 years. The use entirely visible, never concealed, never interrupted. The open and continuous elements were unquestionable. The statutory period had been satisfied 10 years ago. The only question was hostility. She had been prepared to analyze the hostility question on the general law when Walter had called her the Wednesday after sending the survey. He had said, "I found something in the ranch files, a letter from 1994. My father wrote it to the developer." She had said, "Bring it in." The letter had been in a second folder in the ranch office filing cabinet, a folder marked Developer Correspondence, 1993 to 1995, that Walter had found while organizing the ranch records after the estate transfer. The letter was dated June 14, 1994, typed on Harold Marsh's ranch letterhead, addressed to the developer's project manager. It read, in its operative paragraph, "This letter confirms that I am granting your construction crews temporary access across the Marsh family bridge over Sutter Creek for the duration of the Crestwood Meadows construction project. This access is granted as a personal accommodation to your project and does not constitute a permanent right of access, an easement, or any other interest in the Marsh property. When construction is complete, access across the bridge by the subdivision's residents will require a separate recorded instrument, which we have not yet discussed." Margaret had read the letter twice and had set it on the conference table. She had looked at Walter and had said, "Your father knew. He granted temporary construction access and put in writing that the permanent residential access required a separate recorded instrument. The separate recorded instrument was never executed. The developer moved in 140 households across a bridge for which they had only a temporary construction access letter that Harold Marsh wrote to the project manager and kept in his files. Walter had said, he probably assumed the developer would come back to negotiate the easement. Margives had said, the developer never came back. He platted the subdivision, sold 140 lots, and left the easement instrument undone. Your father kept the letter, and apparently never pressed the issue. She had turned the letter over in her hands. She had said, "This letter establishes that the original use was permissive. The developer's construction access was explicitly authorized by Harold Marsh in writing. The residential use that followed was built on that permissive foundation. Permissive use cannot be hostile. Without hostile use, there is no prescriptive easement. The HOA's strongest argument, their only viable argument, is destroyed by a letter your father wrote in June 1994 and filed in a folder labeled Developer Correspondence." Walter had said, "He was a thorough man." Margaret had said, "He was. The letter goes in the file. I'll prepare the demand letter this week. Before I send it, I want to pull the county road department's maintenance records. You mentioned the HOA had submitted maintenance requests over the years. The county road department's file had taken 3 days to obtain through a public records request. The file contained 3 maintenance request submissions from the Crestwood Meadows HOA, one in 2003, one in 2011, and one in 2019, each requesting that the county road department inspect and repair deteriorating conditions on the bridge. The 2003 request cited cracking at the expansion joints. The 2011 request cited guardrail corrosion. The 2019 request cited spalling on the eastern abutment face. Each request had received a written response from the County Road Superintendent's office. Each response was identical in its operative language. The structure identified in your request is not a County Road Department facility. County records do not show this bridge as a county-maintained structure or as having been dedicated to public use. Maintenance responsibility for this structure rests with the private property owner of record. The County Road Department cannot perform maintenance on private structures. 3 times in 28 years, the County Road Department had told the HOA in writing that the bridge was private property. 3 times the HOA had filed the response and continued using the bridge without investigating the private ownership status the county had identified. The responses were dated 2003, 2011, and 2019. And in each of those years, the HOA's board had read the county's written statement that the bridge was private property, noted it, and taken no action to establish a legal right to cross it. Margaret had added the 3 county responses to the file and had called Walter. She had said, "The county road department told the HOA 3 times in writing that the bridge was private property. In 2003, 2011, and 2019. The HOA received written notice of the bridge's private ownership status on 3 occasions over 28 years and never commissioned a title search, never approached your father to negotiate an easement, and never stopped using the bridge." Walter had said, "What does that do to the prescriptive easement theory?" She had said, "It confirms that the use was not hostile in the legal sense. The HOA had written notice that the bridge was private property and continued using it without asserting any adverse claim. But more significantly for the demand letter, it means the HOA cannot claim ignorance of the bridge's private status. 3 county road department letters tell them exactly what the deed records show. When I send the demand letter, they cannot respond that they didn't know. They knew. The county told them. Walter had said, "Draft the letter." She had said, "I'll have it ready Thursday." And Walter, the legal position in 1 sentence, so you understand what we're working with before the letter goes out. He had said, "Go ahead." She had said, "The HOA has been trespassing across your property for 28 years. He had looked at the survey plat on the conference table, the boundary traverse, the abutment locations, the 40-foot approach, all of it within the marsh parcel lines. His father's bridge, his father's land, his bridge now, his land now. The deed recorded in March, and the survey filed with the county surveyor, and the 1994 letter in the file." He had said, "Thursday is fine." He had driven back to the ranch that afternoon and had walked to the bridge at dusk, the March evening cold, the creek running at its spring level 6 feet below the deck, the Crestwood Meadows entry road visible on the far side with its streetlights coming on in the early dark. A car had crossed the bridge while he stood on the western approach, a sedan moving from the subdivision side to the county road side, the driver not looking at Walter, the crossing taking 5 seconds, routine and unremarkable. The same crossing the same driver had probably made 1,000 times. Walter had watched the car reach the county road and turn. He had looked at the bridge deck, the cracked expansion joints, the rusted guardrail pipes, the weathered concrete his father had poured 57 years ago. The structure that 140 households had been crossing every day for 28 years on the strength of a temporary construction access letter that the developer had never converted into a recorded easement. He had pulled his field notebook from his jacket pocket and written a single entry. March 2021. Survey commissioned. Bridge. Marsh parcel. 1967. No easement of record. County Road Department. 3 written denials. 2003/2011/2019. 1994 letter. Permissive use confirmed. Demand letter. Thursday. Matter open. He closed the notebook. A second car crossed the bridge heading into the subdivision, the headlights sweeping briefly across the western approach where he stood. The driver did not slow down. He put the notebook in his pocket and walked back to the ranch house. Thursday was 3 days away, and Margaret Solis had 31 years of quiet title practice and a 1994 letter that had been sitting in a filing cabinet labeled Developer Correspondence for the entire time the HOA had been driving across his family's bridge without a legal right to do so. Harold Marsh had been a thorough man. His son had learned from the best. Margaret had organized the title chain analysis into 4 sections: ownership history, encumbrance history, subdivision plat review, and prescriptive easement analysis. The structure she used for any title dispute where the instrument record was the foundation of the legal position, and the client needed to understand not just the conclusion, but the chain of reasoning that produced it. She had presented it to Walter on a Thursday morning, the documents laid out on the conference table in chronological order from left to right, the oldest instrument at the left edge and the survey plat at the right. 57 years of property history arranged in sequence so that anyone sitting at the table could follow the ownership chain from the government patent to Walter's March 2021 deed without losing the thread. The ownership history section was clean. The government patent for the land encompassing what became Parcel 44-3301-002 had been issued in 1889. The parcel had passed through 3 owners between 1889 and 1951, each transfer by warranty deed, each deed recorded at the county clerk's office within 90 days of execution. Harold Marsh had acquired the parcel by warranty deed in March 1951. The deed describing the full 340 acres, including the Sutter Creek corridor, both banks, and the full western upland to the county road frontage. Harold had held the parcel without interruption from 1951 until his death in January 2021. Walter's deed had recorded in March 2021. 70 years of continuous Marsh family ownership, unbroken, undisputed, documented in the county deed records without a gap. The encumbrance history section was what mattered. Margaret had pulled every recorded instrument affecting Parcel 44-3301-002 from 1889 to the present: liens, easements, right-of-way dedications, access agreements, utility easements, drainage easements, conservation easements, every category of instrument that could affect the parcel's ownership or use. The list was short. A utility easement for a power line along the county road frontage, recorded in 1962, 12 feet wide, running the length of the parcel's western boundary. A mineral rights reservation in the 1951 warranty deed, which Harold had subsequently acquired by quitclaim in 1978. A drainage easement along Sutter Creek's western bank, recorded in 1984 as part of a county flood control project, 20 feet wide, running the length of the creek corridor. No access easement, no right-of-way dedication affecting the bridge or the bridge approach road, no instrument of any kind authorizing any neighboring parcel, the county, or any private party to cross the marsh parcel at the bridge location. The encumbrance record was, on the question of bridge access, entirely blank. Margaret had set the encumbrance summary in front of Walter and had said, "From 1967, when your father built the bridge, to March 2021, when you received the deed, not one recorded instrument was ever executed granting anyone the right to cross that bridge. The utility easement is along the county road. The drainage easement is along the creek bank. Neither one has anything to do with the bridge. The bridge approach road and the bridge structure itself are encumbrance-free," Walter had said, "and the subdivision plat." She had set the plat on the table. The Crestwood Meadows subdivision plat had been prepared by a survey firm and filed with the county on September 8, 1994. The plat covering the 87-acre parcel on the eastern side of Sutter Creek, divided into 140 residential lots, 1 common area parcel, and 1 road parcel. The road parcel was the subdivision's internal street network, and the access road running from the interior loop to the bridge's eastern approach. The plat's title block identified the filing entity as Crestwood Meadows Development LLC. The plat had been approved by the County Planning Commission and signed by the county engineer. The plat showed the bridge in clear graphic terms, the structure spanning Sutter Creek at the subdivision's western edge, the access road running from the bridge's eastern approach to the subdivision's interior loop. The bridge was labeled on the plat as Existing Bridge Structure, Primary Entry. The access road was labeled Main Access Road. Every lot in the subdivision was on the interior side of that road network. The bridge was the only vehicle access point shown on the plat. There was no secondary access road, no emergency access route, no alternative vehicle connection to the county road system. The plat's notes section ran to 12 items, standard subdivision filing notes covering lot dimensions, setback requirements, utility easement reservations, and drainage provisions. Item 11 noted, primary vehicle access to the subdivision is via the existing concrete bridge structure over Sutter Creek. See Sheet 3 for bridge location and dimensions. Item 12 noted, all lots and common areas within this plat are served by the access road shown on Sheet 2. Margaret had set her finger on items 11 and 12 and had said, the developer showed the bridge as the primary entry point on the plat, noted it in the plat's conditions, and filed the plat with the county without a single recorded instrument establishing a legal right to use the bridge. The County Planning Commission approved the plat. The county engineer signed it. Nobody, at any point in the 1994 approval process, asked for the easement instrument that should have been a condition of plat approval. Walter had said, did the developer's title search show the bridge as private property? Margaret had said, I can't know with certainty what the developer's title search showed in 1994 because the title search report isn't in any public record. But the county deed records in 1994 showed exactly what they show now. Harold Marsh's ownership, no easements, no right-of-way dedication, the bridge on private land. A competent title search in 1994 would have found the same thing I found in 2021. Whether the developer's title examiner missed it, found it, and didn't report it, or reported it and the developer proceeded anyway, I can't tell you. What I can tell you is that the instrument that should have been recorded before that plat was approved was never recorded. She had paused and had said, your father's 1994 letter to the developer is the most important document in this file. The letter shows that Harold Marsh was aware of the access question and addressed it. He granted temporary construction access and explicitly said that permanent residential access required a separate recorded instrument. The developer received that letter, acknowledged the distinction between temporary construction access and permanent residential access, and never came back to execute the permanent instrument. Walter had said, my father kept the letter. Margaret had said, he kept it, and he kept it in a labeled folder in an organized filing cabinet for 27 years. He was not a man who lost documents. She had turned to the prescriptive easement analysis, the section she had prepared with the most care because it was the argument the HOA would lead with when the demand letter arrived, and she wanted Walter to understand exactly how the 1994 letter dismantled it before the HOA's attorney tried to make it. The prescriptive easement doctrine, as she had explained to Walter in their first meeting, required 4 elements: open use, continuous use, use for the statutory 20-year period, and hostile use. The first 3 elements were not in dispute. 28 years of daily use by 140 households was open, continuous, and well past the statutory period. The hostility element was the question. Hostile use, in the prescriptive easement context, did not mean aggressive or contentious use. It meant use that was inconsistent with the owner's rights, use that the user exercised as a matter of claimed right rather than by the owner's permission. If the owner had permitted the use was not hostile. If the use had begun as permitted use, it remained permissive in character, regardless of how long it continued. A use that started permissive could not become hostile through the passage of time alone. The user had to take some affirmative act that repudiated the permission and asserted an independent right before the hostile use clock could begin running. The HOA's prescriptive easement claim would argue that 28 years of open, continuous, uninterrupted use had ripened into an easement by prescription. The claim's strength, on its face, was the duration and visibility of the use. The claim's fatal weakness was the 1994 letter. Harold Marsh had granted the developer's construction crews temporary access in June 1994. The letter had used the phrase personal accommodation to describe the grant and had explicitly distinguished it from a permanent right of access or an easement. The developer had received the letter. It had been addressed to the developer's project manager, and the developer's subsequent conduct, completing construction and moving in residents without executing the permanent easement instrument, was consistent with having received it and set it aside. The construction crew's access in 1994 had been explicitly authorized by Harold Marsh in writing. That authorization made the 1994 access permissive by definition. The residential use that followed, beginning when the first Crestwood Meadows residents moved in during 1995, had been built directly on the foundation of the 1994 construction access. The residents had crossed the bridge because the subdivision's developer had crossed the bridge during construction, and the developer had crossed the bridge on the strength of Harold Marsh's 1994 letter. The permission Harold had granted in 1994 had colored every subsequent crossing. A use that originated in permission retained its permissive character until the user took affirmative action to repudiate the permission and assert an independent right, and the HOA had never done that. They had submitted maintenance requests to the County Road Department in 2003, 2011, and 2019, each time receiving written notice that the bridge was private property, and each time they had continued using the bridge without filing any legal instrument, making any adverse claim, or approaching the Marsh family to negotiate the permanent easement Harold's 1994 letter had identified as necessary. Margaret had set the prescriptive easement analysis section in front of Walter, and had said, "The HOA's prescriptive easement claim fails on the hostility element for two independent reasons. First, the 1994 letter establishes that the original use was permissive. Harold granted access, and the developer accepted that grant. Second, the County Road Department's 3 written notices told the HOA on 3 occasions between 2003 and 2019 that the bridge was private property, and the HOA's response on each occasion was to file the letter and continue using the bridge without making any adverse claim. That conduct is the opposite of hostile use. It is acquiescence in the owner's title, combined with continued use by permission." Walter had said, "So the claim fails." She had said, "As a matter of law, on these facts, yes. If this goes to a summary judgment motion, I expect to win it. The 1994 letter is dispositive." He had said, "Write the demand letter." The demand letter had gone out on a Thursday, 12 pages, certified mail, addressed to Diane Crowley as HOA president and to the HOA's registered agent, with a copy to the HOA's management company. Margaret had written it with the directness of an attorney who had 31 years of title dispute experience and a file that was as clean as a title dispute file could be. The letter's first section set out the ownership history, the government patent, the Marsh family ownership chain, the 1967 bridge construction, the survey confirming the bridge's location within the Marsh parcel. The second section set out the encumbrance history. No access easement, no right-of-way dedication, no recorded instrument of any kind authorizing use of the bridge. The third section addressed the 1994 developer's title search failure, the subdivision plat showing the bridge as the primary entry point, the absence of any easement instrument in the plat's conditions, the note in Harold Marsh's files establishing that the developer had been put on written notice that permanent residential access required a separate recorded instrument that was never executed. The fourth section addressed prescriptive easement directly. Margaret had included it because she knew Diane Crowley would call an attorney the day the letter arrived, and she wanted that attorney's first reading of the legal landscape to include a clear statement of why the prescriptive easement theory would fail. She had reproduced the hostility element's legal standard, summarized the 1994 letter's effect on the hostile use analysis, and noted the County Road Department's 3 written notices as additional evidence that the use had never been adverse to the Marsh family's title. She had concluded the section, "The HOA's use of the bridge has been continuous and open. It has never been hostile. The prescriptive easement doctrine provides no relief on these facts." The fifth section stated the demand in 4 numbered points. 1. The HOA would acknowledge in writing, within 30 days, that the Sutter Creek Bridge is private property of Walter Marsh, located entirely within parcel 44-3301-002, and that the HOA has no recorded right of access across the bridge or the western approach road. 2. The HOA would cease unauthorized use of the bridge within 60 days and negotiate in good faith a recorded access easement and bridge maintenance agreement covering the terms of permanent vehicle access, maintenance obligations, capital reserve contributions, and cost share for the bridge's periodic structural inspection and load rating study. 3. The recorded easement and maintenance agreement would be executed and delivered to the county recorder's office within 90 days of the demand letter's date. 4. If the HOA failed to acknowledge the bridge's private ownership, cease unauthorized use, or execute the recorded instruments within the stated periods, Walter would install a gate on the western approach road and lock it, and would file a quiet title action in County District Court, confirming his ownership and the absence of any easement or right-of-way in the HOA's favor. The letter's final paragraph was one sentence. Mr. Marsh has no interest in depriving 140 households of vehicle access to their homes. He has every interest in converting the HOA's 28 years of unauthorized use into a properly recorded legal instrument that serves both parties' interests. The demand periods above provide time for that conversion. What they do not provide is additional time for unauthorized use to continue without a resolution. Diane Crowley had received the demand letter on a Friday morning at the HOA management company's office. The management company's coordinator had called her at 9 a.m. and had said, "There's a certified letter from a property attorney about the bridge. You should read it today." Diane had read it at her kitchen table over a second cup of coffee, working through the 12 pages with the systematic attention of a 14-year board president who had read a great many legal-adjacent documents and who understood that the ones requiring immediate attention had a particular character. This one had that character. She had read the ownership history section without alarm. She knew the bridge existed. She knew the HOA maintained it. She assumed the maintenance history established the HOA's responsibility for it. She had read the encumbrance history section with the first trace of concern. The phrase, "no recorded instrument of any kind," appearing twice in the first two paragraphs. She had read the 1994 developer correspondence section and had set the letter down. She had read the 1994 letter's quoted language twice. This access is granted as a personal accommodation and does not constitute a permanent right of access, an easement, or any other interest in the Marsh property. When construction is complete, access across the bridge by the subdivision's residents will require a separate recorded instrument. She had picked the demand letter back up and had finished reading it. She had called Frank Utley at 10:15. He had said, "Send me everything." She had photographed all 12 pages with her phone and sent them while Frank was still on the line. He had said, "I'll call you Monday. Don't respond to anything before we talk." She had said, "Frank, the bridge is the only way in and out of the neighborhood." He had said, "I know. I'll call you Monday." She had set the letter on her kitchen table and had looked out the window toward the subdivision's main entry road, the pavement running straight from the interior loop to the bridge approach, the same road every resident drove every day, the road the school buses used every morning. The concrete span over Sutter Creek, 40 feet long, 12 feet wide, built by Harold Marsh in 1967, and crossed by 140 households every day for 28 years, on the strength of an easement that had never been recorded. She had picked up her coffee and had thought about the 3 letters the county road department had sent, 2003, 2011, 2019. The letters she had read as president and filed, and not acted on because the bridge was the bridge, and nobody had ever suggested that the HOA's right to use it was anything other than settled. The letters had said private property, and she had read, "not our maintenance responsibility," and had moved on. She had thought about that now, sitting at her kitchen table on a Friday morning, with 12 pages of title chain analysis, and a 1994 letter from Harold Marsh that her attorney needed until Monday to assess. She had put the letter in her HOA file and had poured the rest of her coffee down the sink. Monday was 3 days away, and Frank Utley had 30 years of HOA practice, and whatever he was going to tell her, she already knew it was not going to be simple. Frank Utley had called Diane on Monday morning at 8:45, earlier than he had said, which told her something about how he had spent the weekend. He had said, "I've read everything twice. Come in this afternoon." She had driven to his office at 2 p.m. and had sat across the conference table from a man who had spent 30 years in HOA practice and who had the specific expression of an attorney delivering an assessment his client was not going to find comfortable. He had the demand letter, the quoted sections of the title chain analysis, and a yellow legal pad with notes in the margins. He had set his pen down and had looked at her directly. He had said, "The ownership history is clean. Walter Marsh owns the bridge. The title chain is unbroken from the government patent to his March 2021 deed. There is no gap, no competing claim, no clouded title. The bridge is on his parcel, and has been on his parcel since his father built it in 1967. That part of the letter is correct, and I cannot find an argument against it. Diane had said, "What about prescriptive easement?" He had said, "That's the only argument we have." 28 years of open, continuous, daily use by 140 households is the strongest possible prescriptive easement claim in terms of the duration and visibility factors. No prescriptive easement case ever had more obvious open and continuous use than this one. She had said, "Then we have a strong case." He had said, "We have a strong case on 2 of the 4 required elements. The problem is the other 2, specifically 1, hostility." He had walked her through the hostility doctrine, the way he would walk a judge through it, methodically, without shortcutting the analysis, because he wanted her to understand the legal standard well enough to assess their position herself, rather than taking his conclusion on faith. Prescriptive easement required hostile use. Hostile use meant use without the owner's permission, use asserted as a matter of right rather than tolerance. Permissive use, use the owner had allowed, could not be hostile. A use that had begun permissively retained its permissive character until the user repudiated the permission and asserted an independent adverse right. He had said, "Margaret Solis is going to argue that the 1994 letter from Harold Marsh to the developer establishes that the original use was permissive. Harold granted the developer's construction crews temporary access and described it explicitly as a personal accommodation that did not constitute an easement or permanent right. If a court accepts that the 1994 developer access was permissive, which it almost certainly will because Harold's letter is unambiguous, then the residential use that followed was built on a permissive foundation. And permissive use does not ripen into prescriptive easement, no matter how many years pass." Diane had said, "The construction access and the residential access are different things. Harold let the construction crews in. He didn't let the residents in." Frank had said, "That's the argument I would make. The 1994 letter covered construction access, not residential access. When the residents moved in 1995, they were not operating under Harold's 1994 letter. They were operating without any authorization at all, which is a form of adverse use. The argument is that the hostile use clock started when the first residents moved in, not when the construction crews moved in, and that 28 years of residential use without any permission from the Marsh family satisfies the hostility element." Diane had leaned forward. She had said, "That works." He had said, "It might work if it were the only argument on the table. It might survive a motion to dismiss. It might even survive summary judgment if I argue it correctly. But there is a secondary problem that makes the hostile use argument significantly weaker, and that is the County Road Department letters." He had set 3 documents on the table, copies he had obtained from the County Road Department's public records portal after reading the demand letter, the 2003 maintenance request, and the county's written response. Not a county structure, private property. Maintenance responsibility rests with the private property owner of record. The 2011 request and response, the 2019 request and response, all 3 identical in their operative language, all 3 addressed to the Crestwood Meadows HOA. He had said, "The HOA received written notice from the County Road Department in 2003, 2011, and 2019 that the bridge was private property. On 3 occasions over 16 years, the county told us in writing that the bridge belonged to someone else. And on all 3 occasions, the board, you were president for the last 2, read the letter, filed it, and continued using the bridge without making any legal claim to access rights and without approaching the Marsh family. That conduct is very difficult to characterize as hostile use. Hostile use requires using the property as if you have a right to it, in a manner adverse to the owner. Using property after receiving written notice that it belongs to someone else, without making any legal claim to access, looks much more like continued permissive use than adverse use. Diane had said, "We didn't know we needed to make a legal claim. We thought it was a county structure maintenance question." He had said, "That may be true, but what a court will see is that the HOA was told 3 times that the bridge was private property and took no action to establish a legal right to use it. That is going to make the hostile use argument harder to sustain." She had been quiet for a moment. Then she had said, "What do you recommend?" He had said, "The prescriptive easement theory is viable enough to assert. I am not going to tell you it is a strong case, because the 1994 letter is a significant obstacle, and the county road department letters make the hostile use argument complicated. But it is the only legal theory available to the HOA, and 28 years of continuous use is not nothing. I can file a declaratory judgment action asserting prescriptive easement and make the argument that the residential use was independent of the 1994 construction access, and that 28 years of adverse residential use satisfies the statutory period." She had said, "File it." He had said, "I want to note for the record that I assess this case as difficult before recommending litigation." She had said, "Noted. File it." The board meeting had been on a Wednesday evening, all 5 members present, Diane at the head of the table, Frank on speakerphone, 22 residents in the gallery who had heard through the community forum that something was happening with the bridge. Frank had presented the legal situation with the specific care of an attorney, managing the gap between his private assessment and his public presentation, describing the HOA's position as defensible, the prescriptive easement theory as legally recognized and supported by decades of documented use, and the demand letter as an opening negotiating position from a property owner who had just inherited and was testing the strength of any potential claims. A resident named Paul Henning, Unit 83, an accountant who had lived in Crestwood Meadows since 2001, and who had submitted the 2003 maintenance request to the county road department himself, had raised his hand and said, "The county told us in 2003 it was private property. I sent that letter in. I have a copy. Why didn't anyone look into it then?" Diane had said, "The county's maintenance denial didn't trigger any alarm because the bridge was functioning and residents were using it without interruption. There was no visible ownership dispute." Paul Henning had said, "The county said it was private property. That seems like an alarm." Diane had said, "In hindsight, yes. At the time it was processed as a maintenance jurisdiction question. The board is addressing it now." Frank had said from the speakerphone, "The HOA's legal position is based on 28 years of documented continuous use, which is a recognized basis for establishing access rights under state law. The board is asserting that claim through the appropriate legal process." The vote had been 4-1, Paul Henning voting against, the remaining 4 voting to reject the demand and file the declaratory judgment action. Diane had recorded the vote in the meeting minutes and had moved to close the meeting. The community meeting had followed 5 days later, all 140 units notified, the clubhouse at capacity, Diane at the front with the composure of a president who had organized 14 years of community governance and who had learned that the manner in which difficult information was presented mattered as much as the information itself. She had said, "The HOA has received a demand letter from the attorney for Walter Marsh, who inherited the property on the western side of Sutter Creek earlier this year. Mr. Marsh's attorney has asserted that the bridge over Sutter Creek is private property, and that the HOA lacks a recorded legal right to use it. The board has reviewed the matter with HOA counsel and has voted to assert the HOA's prescriptive easement rights, which are based on 28 years of continuous, open, uninterrupted use of the bridge by the HOA and its residents." She had said, "Our access to the bridge is secure. The legal process will confirm our right to use it." A woman in the second row had raised her hand and asked, "What if the legal process doesn't confirm it?" Diane had said, "Our counsel has assessed the prescriptive easement theory as viable, and the board has confidence in the HOA's legal position." The woman had said, "But what if it doesn't work? What happens to our access?" Diane had said, "That is not the outcome we anticipate. The board is proceeding on the basis of the HOA's legal rights, and we expect those rights to be confirmed." She had not answered the question. The woman had written something on the back of her program and had not raised her hand again. Frank had filed the declaratory judgment action on the following Monday, the complaint asserting prescriptive easement on the grounds of 28 years of open, continuous hostile residential use of the Sutter Creek Bridge by the Crestwood Meadows HOA and its 140-member households, seeking a court declaration that the HOA had acquired an easement by prescription and had a legally enforceable right of access across the bridge in perpetuity. The complaint had cited the duration of use, the open and visible character of the daily crossings by residents and their vehicles, and the absence of any interruption or objection from the Marsh family during the 28-year period. The complaint had not addressed the 1994 letter, which Frank had not yet seen. The letter had been described in Margaret's demand letter, but had not been attached as an exhibit, and Frank had noted its absence and had hoped, without confidence, that its significance in the case file was smaller than Margaret's characterization suggested. Walter had received the complaint from the process server on a Thursday morning and had read it at the kitchen table of the ranch house, the same table where his father had written the 1994 letter 27 years earlier, the same ranch house where the filing cabinet sat with its labeled folders in the office down the hall. He had read Frank's prescriptive easement argument, the 28 years of use, the open and continuous elements, the claim that residential use after 1995 was independent of and separate from the 1994 construction access. He had set the complaint on the table and had called Margaret. He had said, "They filed. Prescriptive easement, as expected. They're arguing the residential use after 1995 was independent of the 1994 construction access and satisfies the hostility element on its own." Margaret had said, "I expected that argument. It's the only viable theory they have, and Frank Utley is experienced enough to know how to frame it. Send me the complaint." He had sent it within the hour. She had read it and had called back by mid-afternoon. She had said, "The complaint doesn't reference the 1994 letter specifically, which means Frank either doesn't have it yet or is hoping to distinguish it at trial rather than address it in the pleading. Either way, the answer is the same. I'll prepare the response this week." Margaret had built the answer around two independent grounds, the permissive use doctrine and the county road department letters, and had attached the 1994 letter as Exhibit A. The permissive use argument occupied the response's core. She had set out the full text of the 1994 letter, Harold Marsh's grant of temporary construction access to the developer's project manager, the explicit language describing the grant as a personal accommodation that did not constitute a permanent right of access or an easement, the explicit statement that permanent residential access required a separate recorded instrument. She had then set out the legal analysis. The developer's construction crews had crossed the bridge in 1994 by Harold Marsh's explicit permission. The subdivision had been built on the eastern bank using that permitted access. The first residents had moved in through the same entry road the construction crews had used, crossing the same bridge the construction crews had crossed on the strength of the same 1994 authorization. The residential use had originated in permitted use and had retained its permissive character. She had addressed Frank's independent use argument directly, the theory that residential use after 1995 was a distinct category from construction access and could satisfy the hostility element independently. The response stated, "The HOA's argument requires the court to treat the residential use that began in 1995 as legally independent of the construction access that preceded it. This argument fails because the residential use was not independent. It was the intended continuation of the access the developer had established during construction." Harold Marsh's 1994 letter identified the permanent residential access instrument as the next necessary step. The developer's failure to execute that instrument did not transform the residential use into hostile use. It left the residential use in the same permissive posture the construction access had established, without the permanent instrument Harold had identified as required. The county road department letters had occupied the response's second ground. 3 written notices to the HOA, 2003, 2011, 2019, each stating that the bridge was private property and that maintenance responsibility rested with the private property owner of record. Margaret had set out the sequence and had argued, an entity asserting hostile use must use the property as if it has a right to do so, in a manner adverse to the true owner's title. The HOA's receipt of 3 written notices from the county road department confirming the bridge's private ownership status and its continued use of the bridge after each notice without making any legal claim to access rights or approaching the Marsh family to negotiate a recorded instrument, is inconsistent with hostile use. The HOA's conduct after each county notice was acquiescence in the private ownership claim, combined with continued use, a posture indistinguishable from permissive use. The response had concluded with a motion for summary judgment. The argument that the 1994 letter was undisputed, its legal effect on the hostility element was a matter of law rather than a factual dispute, and the HOA's prescriptive easement claim failed as a matter of law on these undisputed facts. Margaret had filed the answer in motion on a Tuesday. She had mailed a copy to Frank Utley's office the same afternoon. Frank had received Margaret's filing on Thursday morning. He had opened the envelope at his desk, read the cover page, and turned to Exhibit A. He had read the 1994 letter, Harold Marsh's typewritten grant of temporary construction access, the personal accommodation language, the explicit statement that permanent residential access required a separate recorded instrument, and had set it on his desk. He had sat for a moment with the letter in front of him. He had pulled his legal pad and had written at the top, 1994 letter, dispositive? He had written 2 lines of analysis beneath the question, had crossed them out, had written 2 more, and had set the pen down. He had called Diane at 11 a.m. He had said, Margaret Solis filed the answer this morning. She attached the 1994 letter as an exhibit. Diane had said, does it change anything? He had said, it confirms what I told you in our first meeting. The letter is going to be the central issue in the summary judgment motion. I need to assess whether I have a viable response to the argument that the 1994 construction access was permissive and that the residential use built on it cannot be hostile. She had said, do you have a viable response? He had been quiet for a moment. The specific silence of an attorney who had a practiced answer to that question, and a truthful answer, and who was deciding which one to give. He had said, I'll have a full assessment for you by end of week. He had looked at the 1994 letter on his desk after the call, Harold Marsh's letterhead, the June 14, 1994 date, the phrase personal accommodation in the second sentence of the operative paragraph, the phrase separate recorded instrument in the final sentence. Harold Marsh had been a thorough man. He had written the letter, kept the copy, filed it in a labeled folder, and left it in an organized filing cabinet for his son to find 27 years later. Frank Utley had 30 years of HOA practice. He had never seen a case where the opposing party's foundational document had been sitting in a filing cabinet for 27 years, waiting to be found by the right person at the right time. He began writing his end-of-week assessment on a legal pad, and found, by the second page, that he already knew what it was going to say. Frank Utley's end-of-week assessment had been 4 pages, the most honest document he had produced in the litigation, written for Diane Crowley's eyes and not for a court, the kind of assessment an attorney writes when the gap between the client's expectations and the legal reality has grown wide enough that closing it with careful phrasing is no longer responsible practice. The first page had restated the prescriptive easement elements and the HOA's position on each. Open use, unquestionable. Continuous use, unquestionable. Statutory period, satisfied by a margin of 8 years. Hostile use, the problem. The first page had ended mid-analysis, the second page beginning where the first had stopped, the transition unmarked, the document written in the unbroken prose of a man thinking through a problem rather than presenting a polished position. The second and third pages had been the 1994 letter analysis. Frank had worked through every available counter-argument with the methodical attention of an attorney who had spent a career finding viable theories in difficult fact patterns, and who was now finding, for the first time in this case, that the viable theories were not there. He had written, the independent use argument, that residential access after 1995 was legally distinct from the 1994 construction access, requires the court to treat Harold Marsh's permissive grant to the developer as a bounded transaction that ended when construction ended, leaving the residential use that followed in a legal vacuum that could be characterized as adverse. This argument has surface plausibility, but fails on examination because the residential use was not independent. It flowed directly from the access the developer established. The residents did not arrive at the bridge from a separate direction or through a separate history. They arrived because the developer built the subdivision's entry road to the bridge's eastern approach on the strength of Harold Marsh's 1994 permission. The chain of access is unbroken from the 1994 letter to the first resident's first crossing in 1995. The fourth page had been the assessment's conclusion, which Frank had written without softening. The summary judgment motion will be decided on whether the court accepts that the 1994 letter's permission extended through the residential use period, or accepts the HOA's argument that the residential use was independent. I assess the probability that the court accepts the HOA's argument at less than 30%, given the letter's language and the County Road Department's 3 written notices. I recommend the board authorize me to approach Margaret Solis about a negotiated easement before the summary judgment hearing. The motion is scheduled for 60 days out. We have time to negotiate if the board decides to use it. He had sent the assessment to Diane on Friday afternoon by encrypted email. He had written in the cover message, "Please read all 4 pages before we talk." Diane had called him Saturday morning. She had said, "Less than 30%. He had said, "On the summary judgment motion, yes. The 1994 letter is the problem. It is a clean document with unambiguous language, and it goes directly to the dispositive element. I have been looking for a response to it since I read it Thursday morning, and I have not found one that I would call strong." She had said, "What happens if we lose the motion?" He had said, "If the court grants summary judgment for Walter, the prescriptive easement claim is dismissed as a matter of law. The HOA's legal argument for bridge access is gone. Walter then gates the bridge, and the HOA has no legal basis to challenge the gate." She had said, "He's already put a gate up." Frank had been quiet. He had said, "When?" She had said, "Thursday. A resident called me. He installed a gate on the western approach, a steel farm gate, locked, with a sign. But he hasn't locked it yet. It's there. It's visible. The sign says private property. Marsh family, trespassing prohibited. But residents are still crossing. The gate is open." Frank had said, "The gate's presence is a legal act regardless of whether it's locked. He's put the HOA on notice that the bridge approach is private property under his control. If the summary judgment motion goes against us and he locks it, we have no injunctive relief argument that survives the court's ruling." Diane had said, "What do you recommend?" He had said, "Negotiate. Call me Monday and we'll talk about how to approach Margaret Solis." She had said, "The board voted to litigate." He had said, "The board voted on an assessment that was less complete than the one I gave you Friday. The 1994 letter wasn't in my hands when the board voted. It is in my hands now. My recommendation has changed." She had said she would think about it. She had not called Monday. The gate had gone in on a Thursday afternoon in late October, Walter working alone. The gate posts set in concrete the previous weekend. The gate itself a standard steel farm gate 8 feet wide, the kind sold at every agricultural supply store in the county, hung on heavy strap hinges with a drop bar and a padlock hasp. He had not locked the padlock. He had left the gate standing open against the right-hand post, held back by a hook and eye latch, the gap through the gate clear, the bridge approach and the bridge deck visible beyond it. He had screwed the sign to the left-hand gate post at eye level, a 12 by 18-inch aluminum sign, the text in black on white. Private property, Marsh family parcel, 44-3301-002. No trespassing without permission of owner. W. Marsh, owner. Below the text he had added, in smaller type, "Inquiries. Contact Margaret Solis, attorney at law," followed by Margaret's office phone number. He had stood back and looked at the gate in the afternoon light, the steel frame, the open gap, the sign on the post, the bridge deck beyond. The gate was not stopping anyone. Every resident who had crossed the bridge on Thursday morning was crossing it on Thursday afternoon. The gate open against the post, the sign visible to anyone who looked at the post as they drove through. Most did not look. A few slowed. One had pulled over on the bridge deck and had photographed the sign with a phone. He had written in his survey log, October 24th, 2023, gate installed, western approach, parcel 44-3301-002. Gate, open, unlocked. Sign, posted. Notice of private ownership, served by physical presence. Padlock, available. Summary judgment hearing, 58 days. The 1994 letter had its own physical history, a quality that Margaret had thought about when she filed it as Exhibit A, and that the letter itself communicated to anyone who handled it. It was typed on a manual typewriter, the keystrokes slightly uneven in the manner of a man who typed competently but not professionally. The paper, a cream-colored bond that had yellowed at the edges over 27 years without losing its structural integrity. Harold Marsh had signed it in blue ballpoint pen, a careful, legible signature. The letters formed with the deliberateness of a man who had signed documents throughout his adult life and understood that a signature was a representation. The envelope it had been filed in was still in the folder, the developer's project manager's name and address typed on the front, the Marsh Ranch return address in the upper left corner, the postmark dated June 16, 1994, 2 days after the letter's date, the original mailing confirmed by the postmark on the envelope Harold had kept with the copy. Margaret had held the letter at her desk the morning she filed it, and had read it one more time before placing it in the exhibit folder. The operative paragraph was the second of 3, short, 27 words in its key sentence. This access is granted as a personal accommodation to your project and does not constitute a permanent right of access, an easement, or any other interest in the Marsh property. Harold had used 3 separate formulations: not a permanent right of access, not an easement, not any other interest, as if he had understood, in June 1994, that a single formulation might be argued around, and had used all 3 to foreclose the argument. The final sentence of the operative paragraph: when construction is complete, access across the bridge by the subdivision's residents will require a separate recorded instrument, which we have not yet discussed. He had known exactly what he was doing. He had known the developer would need a permanent easement, had told the developer that in writing, had kept the copy, and had waited for the developer to come back. The developer had never come back. Harold had kept the letter for 27 years in a folder with a tab that made it findable in under 10 minutes. And when his son had inherited the property and gone to the filing cabinet, it had been exactly where Harold had put it. The legal effect of those 55 words was the destruction of a prescriptive easement claim that 28 years of daily use by 140 households had built. The hostile use clock required a starting point, a moment when the use shifted from permitted to adverse. Harold's letter set the 1994 construction access as explicitly permitted. The developer's failure to execute the permanent instrument had not started the hostile use clock. It had left the access in a legal limbo that looked like continued permission rather than adverse use. The residents who had moved in from 1995 onward had inherited that limbo without knowing it, crossing a bridge every day that they had every reason to believe was part of their neighborhood's infrastructure, and no recorded instrument to confirm that belief. Margaret had filed the exhibit folder at the courthouse on a Tuesday morning, and had sent Frank Utley a copy by messenger the same afternoon. The messenger had delivered it to Frank's office at 2:15 p.m. Frank's paralegal had signed for it and had set it on his desk. He had read it at 3 p.m. The summary judgment motion was scheduled for a Thursday morning, 60 days from filing. Standard motion calendar for the county district court. The hearing before Judge Alma Reyes, who handled the court's property and title docket, and whose background included 7 years as a title examiner before law school. Margaret had noted Judge Reyes's background in her motion preparation, with the specific attention of an attorney who knew that a former title examiner would read the 1994 letter's language and the encumbrance record with professional fluency rather than general legal reasoning. The motion's argument ran to 18 pages. The first 4 pages established the legal standard for summary judgment in prescriptive easement cases. No genuine dispute of material fact, entitlement to judgment as a matter of law. The next 6 pages address the hostility element exclusively, building the argument from the 1994 letter outward. Margaret had structured the argument in 3 layers: the letter's direct effect, the independent residential use theory's failure, and the county road department letters as corroborating evidence of the use's non-hostile character. The direct effect layer was the motion's foundation. Harold Marsh had granted the developer's construction crews temporary access in June 1994 by an explicit written instrument. The instrument's language was unambiguous: personal accommodation, no permanent right of access, no easement, no other interest, Permanent residential access requires a separate recorded instrument. The developer had accepted that grant and used the bridge accordingly. The grant was permissive by its own terms. Nothing in the grant's language or in any subsequent instrument had converted the permissive use into hostile use. The independent residential use layer addressed Frank's best counter-argument with the thoroughness of an attorney who had anticipated it and prepared for it before the complaint was filed. The HOA would argue that the residential use beginning in 1995 was legally independent of the 1994 construction access, that when the construction crews finished and the residents moved in, the residents were not operating under Harold's 1994 permission, because Harold's permission had been addressed to the developer, not to future residents. Margaret's response to this argument was built on the physical continuity of the access. The residents had moved into a subdivision whose entry road had been built to the bridge's eastern approach by construction crews operating under Harold's permission. The entry road itself was the product of the permitted access. The residents had not arrived at the bridge through any independent path. They had arrived through infrastructure that existed because Harold had permitted the developer to build it. The permission was not an agreement between Harold and the residents, but its effect was indistinguishable from permission. The residents had crossed the bridge from the first day because the bridge was there and the road led to it, on the foundation of a development that had been constructed with Harold's authorization. The county road department layer presented the three letters as evidence of the use's character from the HOA's perspective. The HOA had been told in 2003, 2011, and 2019 that the bridge was private property. After each notice, the HOA had not made an adverse claim, had not filed any legal action, had not approached the Marsh family. This conduct, continuing to use property after receiving written notice of its private ownership status, without asserting any adverse right, was the conduct of a party that understood its use was permitted, or at least not opposed, not the conduct of a party asserting a hostile claim to access rights. The motion's conclusion asked Judge Reyes to grant summary judgment, dismissing the HOA's prescriptive easement claim with prejudice, on the ground that the hostile use element could not be satisfied as a matter of law, on the undisputed facts established by the 1994 letter, the county road department correspondence, and the title chain record. Frank had received the full motion package, the brief, the exhibits, the proposed order, on a Tuesday, and had read it through by Wednesday afternoon. He had read the 18-page brief carefully, had reread the three-layer hostile use analysis, and had sat at his desk for 20 minutes after finishing, with a legal pad on which he had written 4 potential counter-arguments and crossed out all 4. He had called Margaret on Thursday morning. She had picked up on the second ring and had said, "Frank." He had said, "I read the motion." She had said, "I know." He had said, "The 1994 letter. The language is unambiguous." She had said, "Yes." He had said, "The independent residential use argument. I think I can make it survive a motion to dismiss, but I'm less confident about summary judgment in front of Reyes. She's going to read the letter as a former title examiner reads a recorded instrument." Margaret had said, "She's going to read it the way it was written." Frank had said, "I want to have a conversation about resolution, not a concession, a conversation. Is Walter open to talking about terms before the hearing?" Margaret had said, "He's been open to talking about terms since the demand letter. The demand is still on the table. Call me next week with a specific proposal, and I'll take it to him." Frank had said, "The gate." She had said, "The gate is open. It's been open since he installed it. He hasn't locked it." Frank had said, "If we begin settlement discussions, will it stay open?" She had said, "Walter installed the gate as notice of ownership, not as a blockade. As long as there's an active good faith negotiation, he has no reason to lock it. If the negotiation stalls, or the HOA files any additional pleadings, I can't make that representation." Frank had said, "Understood." The call had lasted 4 minutes. After it ended, Margaret had added a note to the case file. Frank called, wants to discuss resolution, gate question, confirmed open, pending good faith negotiation, referred to next week for specific proposal, summary judgment hearing, 53 days. She had set the note in the file and had looked at the motion on her desk. 18 pages, 3 exhibits, Judge Reyes's name in the caption. The hearing was 53 days out. The gate was open on the western approach, the padlock hanging unlocked on the hasp, the sign on the gate post visible to every resident who crossed the bridge. Walter had installed the gate without asking what it would produce. He had installed it because the bridge was on his property, and the sign on the gate post said so, and the padlock was available when the time came to use it. The gate was information. What Frank Utley did with it was Frank Utley's decision. He had made his call. The conversation had been 4 minutes. The summary judgment hearing was 53 days away, and the padlock was still hanging open on the hasp of a gate that every Crestwood Meadows resident drove past twice a day, reading the sign whether they intended to or not. Harold Marsh had been a thorough man. His son had learned to let documents do the talking. Judge Reyes had scheduled the summary judgment hearing for a Thursday morning in December. Courtroom 2, 9 a.m. The docket showing 2 other matters before Walter's case that had settled by 8:50, leaving the courtroom clear when Margaret and Frank took their positions at the respective counsel tables at 5 minutes to 9. Frank had filed his opposition brief 3 weeks after Margaret's motion, 22 pages, the independent residential use argument built as carefully as he could build it, the counter-analysis of the 1994 letter's scope, emphasizing the distinction between the developer as addressee and the residents as a distinct class of users who had never been party to Harold's permission and had therefore never been bound by its permissive character. He had filed it knowing its weakest point and knowing Judge Reyes would find the same point he had found. Margaret had filed a reply brief 11 days later, 8 pages. The reply focused entirely on dismantling the independent residential use argument, the physical continuity of the access infrastructure anchoring the analysis. She had added 1 paragraph she had not included in the original motion. The developer received Harold Marsh's 1994 letter, acknowledged its terms by proceeding with construction, and sold 140 lots to buyers who would use the bridge as their primary access. The developer's failure to execute the permanent easement instrument Harold had identified as required did not create a class of innocent adverse users. It created 140 households who had unknowingly purchased lots whose access depended on a legal instrument that did not exist. The equities of that situation may be compelling in a negotiated resolution. They do not satisfy the legal requirement of hostile use. Judge Reyes had read both briefs before the hearing and had asked 3 questions from the bench, each directed to Frank, each aimed at the independent residential use theory's weakest joint. The third question had been, Mr. Utley, if the residence use was independent of the 1994 construction access, when specifically did the hostile use clock start, and what act by the HOA or its residents constituted the repudiation of Harold Marsh's permission that started it? Frank had answered for 4 minutes. When he finished, Judge Reyes had made a note on her legal pad and had said, "Thank you, I'll have a ruling within 10 days. The ruling had arrived on a Wednesday morning, 8 pages, signed by Judge Reyes, the caption reading, "Order granting defendant's motion for summary judgment." The ruling's analysis had taken 5 pages to reach its conclusion, and the conclusion was unambiguous. The 1994 letter established permissive use at the origin of the access. The developer had accepted Harold Marsh's temporary construction access grant and had proceeded on that basis. The residential use that followed was not legally independent of the construction access. It was the residential continuation of access that the developer had established with Harold's permission, using infrastructure the developer had built on the strength of that permission. The hostile use clock had never started because the permission had never been repudiated. The HOA's prescriptive easement claim failed as a matter of law on the hostile use element. Summary judgment was granted. The prescriptive easement claim was dismissed with prejudice. Margaret had called Walter from the courthouse parking lot at 11:15 a.m. She had said, "Full summary judgment. Prescriptive easement dismissed with prejudice." Reyes accepted the permissive use analysis completely. He had said, "The gate." She had said, "Lock it." He had driven to the bridge that afternoon and had swung the gate closed across the western approach, the steel frame moving on the strap hinges, the drop bar seating in the receiver post socket, the gate spanning the full width of the approach road, the bridge deck visible beyond the bars. He had taken the padlock from the hasp, threaded it through the drop bar's eye and the receiver post's staple, and clicked it shut. He had stepped back and looked at the locked gate, the sign on the left-hand post, the padlock on the drop bar, the bridge deck beyond, the Crestwood Meadows entry road, visible on the far side with the afternoon's first returning residents appearing at the eastern approach. A car had reached the bridge's eastern end and had stopped. The driver had looked at the locked gate. The car had sat for a moment and then had reversed back into the subdivision. He had written in his survey log, December 14th, 2023. Summary judgment granted. Prescriptive easement dismissed with prejudice. Gate locked, 2:34 p.m. Padlock, engaged. Access, suspended pending recorded easement instrument. He had driven back to the ranch without looking in the mirror. Diane had been in a board meeting about the holiday lighting assessment when her phone had shown 4 missed calls from residents in 20 minutes. She had stepped out of the meeting and had called the first number back. The resident had said, "The gate is locked. Nobody can get in or out." She had called Frank immediately. He had already seen the ruling in the court's electronic filing system and had been waiting for her call. He had said, "The motion was granted. Prescriptive easement dismissed with prejudice. Walter locked the gate this afternoon." She had said, "What does dismissed with prejudice mean?" He had said, "It means the claim is gone. We cannot refile it. The prescriptive easement theory is finished. The court ruled as a matter of law that the hostile use element cannot be satisfied on these facts. The 1994 letter is in the judgment. It is the reason the claim failed, and it will be in any appeal record as well." She had said, "Can we appeal?" He had said, "Yes. The probability of a different outcome on appeal is low. The ruling follows the law correctly on the undisputed facts. An appellate court will review it de novo, but will read the same letter and apply the same legal standard." She had said, "So the gate stays locked." He had said, "Until there is a recorded easement instrument, yes." She had been quiet for a moment. Then she had said, "What is the detour?" He had said, "The county road to the south runs 2 miles to the next intersection that connects to the subdivision's eastern perimeter. The alternative access adds approximately 18 minutes to every trip in and out of the neighborhood. The county road does not have a school bus route serving Crestwood Meadows. Buses use the bridge approach. The school district would need to reroute." She had said, 18 minutes each way." He had said, 36 minutes round trip, for every resident, every day. The emergency board meeting had been that evening. All 5 members, Frank on the phone, the clubhouse filled beyond capacity with residents who had spent the afternoon driving the 2-mile detour and doing the arithmetic. Paul Henning had arrived early and had taken a seat in the front row with a printed copy of Judge Reyes's ruling that he had downloaded from the court's public filing portal. Frank had presented the legal situation from the speakerphone with a directness he had not used in the community meeting 2 months earlier. The summary judgment ruling, the prescriptive easement dismissal, the 1994 letter's role in the outcome, the appeal's low probability of success. He had said, "Walter Marsh holds clear title to the bridge. The court has confirmed that the HOA has no legal right to cross it. The gate is locked. The HOA's only path to restored access is a negotiated recorded easement. There is no litigation strategy remaining that has a reasonable probability of reopening the bridge." A resident in the 3rd row had said, "What about adverse possession? Couldn't we claim ownership of the bridge itself after 28 years? Frank had said, "Adverse possession requires the same hostile use element as prescriptive easement, applied to ownership rather than access rights. The 1994 letter defeats it on the same grounds." The court's ruling forecloses both theories. The resident had said, "There has to be something." Frank had said, "There is something. It's a negotiated easement. It is the only thing." Paul Henning had raised his hand from the front row and had said, "What are Walter Marsh's terms?" Frank had said, "The demand letter from October set out 4 points: written acknowledgement of private ownership, cessation of unauthorized use, a recorded access easement, and a recorded bridge maintenance agreement. The demand letter is still on the table. Margaret Solis confirmed it has not been withdrawn." Paul Henning had said, "The board had the demand letter in October and voted to litigate instead of negotiate. The prescriptive easement theory has now been dismissed with prejudice by a judge who used to be a title examiner and who read a letter that Harold Marsh wrote in 1994 and kept in a filing cabinet for 27 years. I would like to know what the board's assessment of the negotiation option looks like now." No board member had answered for a moment. Diane had said, "I'll call Walter Marsh tomorrow morning." She had called at 8 a.m. He had answered on the 3rd ring. his voice carrying the unhurried quality of a man who had been expecting the call and had nothing urgent on his schedule. She had said, "Mr. Marsh, this is Diane Crowley, HOA President, Crestwood Meadows. I'm calling about the bridge." He had said, "I know who you are, Ms. Crowley. What would you like to discuss?" She had said, "The easement. We'd like to negotiate the easement." He had said, "Call Margaret Solis. Her number is on the sign on the gate post." She had said, "I've seen the sign." He had said, "Then you have her number. Call her today. She'll be expecting it." He had ended the call. Diane had sat with the phone in her hand for a moment, and had then opened her contacts and found the number she had photographed from the gatepost sign 3 weeks earlier when she had driven to the bridge the afternoon the gate went up. She had dialed Margaret Solis's office at 8:07 a.m. Margaret had picked up on the second ring and had said, "Ms. Crowley, I've been expecting your call. Shall we find a time this week to discuss terms?" The gate was locked on the western approach. The bridge deck was visible beyond the bars in the December morning light, the creek running below at its winter level, the Crestwood Meadows entry road empty on the far side. The school buses were running the 2-mile detour. Every resident in 140 households was adding 36 minutes to their day. The demand letter had been on the table since October. Margaret Solis had 31 years of easement practice and a calendar that was open Thursday afternoon. The negotiation had opened on a Thursday afternoon in Margaret Solis's conference room. Margaret and Walter on one side of the table, and across from them a woman named Carol Vreeland, retained by the HOA's board 10 days after the summary judgment ruling on the specific recommendation of Paul Henning, who had called 3 property attorneys before finding one whose practice centered on title disputes and easement drafting, rather than HOA collections and covenant enforcement. Frank Utley had not been replaced by a board vote or a formal termination. Diane had called him the morning after the emergency meeting and had said the board was bringing in specialized easement counsel to handle the negotiation. Frank had said he understood. The call had lasted 6 minutes and had been the most comfortable conversation either of them had managed since the demand letter arrived in October. Carol Vreeland had read the full case file before the Thursday meeting. The demand letter, the title chain analysis, the 1994 letter, the summary judgment motion and opposition briefs, Judge Reyes's ruling. She had called Margaret on Wednesday to say she had read everything and wanted to confirm one point before the meeting. Was the demand letter's framework still the starting structure, or was Walter coming to the table with revised terms given the ruling? Margaret had said, "The framework is the same. The ruling improved Walter's position, but he is not here to extract maximum value from a locked gate. He is here to get a recorded instrument that should have been recorded in 1994. Carol had said, "That's useful to know. I'll see you Thursday." Walter's terms had been set out in 4 points, the same 4 the demand letter had established in October, Margaret presenting them at the meeting's opening without preamble. The first point was the permanent recorded access easement, appurtenant to the HOA's common area parcel, running with the land, covering vehicle and pedestrian access across the bridge and the western approach road for the benefit of all current and future Crestwood Meadows residents. The easement's recitals would acknowledge the bridge's private ownership status and the HOA's legal right of access through the recorded instrument, rather than through any prior use or prescription. The easement would include a maintenance access right, allowing Walter and his assigns to access the bridge structure for inspection and maintenance without prior notice. The second point was the annual bridge maintenance assessment, a fixed annual payment from the HOA to Walter, covering the HOA's proportionate share of routine bridge maintenance costs, calculated on a formula tied to the bridge's estimated annual maintenance budget and the HOA's exclusive use of the structure as its primary vehicle access. The assessment would be recorded as a covenant running with the HOA's common area parcel, binding on successor boards and successor owners. The third point was the capital reserve contribution, a lump sum payment at closing covering the bridge's next scheduled structural inspection and load rating study, the inspection being overdue by Walter's assessment of the structure's condition and the county's load rating requirements for bridges used as primary subdivision access. The contribution amount would be based on a licensed structural engineer's inspection cost estimate that Walter had obtained before the meeting. The fourth point was the settlement payment, a lump sum covering 28 years of uncompensated use at a per-year figure Margaret had set, plus Walter's documented legal costs for the declaratory judgment proceeding from the demand letter through the summary judgment ruling. Carol had read the 4 points and had said, "The easement terms and the maintenance assessment are acceptable in principle. The capital reserve contribution requires me to review the inspection cost estimate before I can advise the board. The settlement payment, the 28-year figure, I need to take back to the board." Margaret had said, "The 28-year figure is the one point Walter feels strongly about. The HOA had 3 written notices from the county road department over 28 years that the bridge was private property. The settlement payment reflects the period during which the HOA had notice and did not act." Carol had said, "I understand the basis. I need the board to authorize the number." The first meeting had ended after 2 hours, with the easement structure and maintenance assessment framework agreed in principle, the capital reserve contribution and settlement payment figures to be resolved in the second session. The second session had been the following Tuesday, Carol having spent the intervening days presenting the terms to the board and working through the numbers with the HOA's reserve fund manager. The board had approved the capital reserve contribution after reviewing the inspection cost estimate, which Carol had confirmed against a second estimate she had obtained independently. The settlement payment had taken 40 minutes of the Tuesday session, Carol working within a board-authorized range, Margaret holding Walter's floor, the gap between them closing in 3 increments as each party made a single adjustment. The final number had landed at a point both sides could record without qualification. The instrument drafting had taken 2 additional weeks, Carol and Margaret exchanging red lines on the easement document and the maintenance covenant, the legal descriptions reviewed against Walter's survey plat, the easement's boundary confirmed against the parcel map, the maintenance assessment formula stress-tested against the bridge's estimated maintenance cost range. Margaret had insisted on one recital language addition that Carol had initially resisted and then accepted on the second exchange. A sentence in the easement's recital stating that the HOA's access right derived exclusively from the recorded instrument and not from any prior use, prescription, or implied permission. Carol had called Margaret after accepting the recital language and had said, "The board understands why that language is there." Margaret had said, "Walter wants it clear for every future board that reads the easement." Carol had said, "It's clear." The instruments had been executed at a title company's closing table on a Monday morning in mid-January, Walter and Diane signing across the table from each other for the first time in the proceeding, Carol and Margaret on their respective sides, the title company's closer moving the documents through in sequence. The easement first, the maintenance covenant second, the settlement payment wire confirmed before the signatures, the capital reserve contribution check exchanged at the table. Diane had signed her name on the easement's signature line and had set the pen down. She had not said anything. Walter had signed and had set his pen down and had looked at the documents on the table, the easement, the maintenance covenant, the legal descriptions matching his survey plat, the recital language acknowledging the bridge's private ownership, the instruments his father's 1994 letter had identified as necessary, executed 29 years later than Harold had anticipated. The closer had said, "I'll take these to the recorder's office this afternoon. You'll have the confirmed instrument numbers by end of business." Walter had driven to the bridge the following morning, the January dawn cold and clear, the frost on the western approach road crunching under his boots as he walked from the truck to the gate. He had taken the padlock from the drop bar, unthreaded it from the hasp, and set it in his jacket pocket. He had lifted the drop bar from its receiver socket, walked the gate back on its hinges until it rested against the right-hand post, and hooked the eye and hook latch to hold it open. He had stood at the open gate and looked at the bridge, the concrete deck, the pipe guardrails, the frost on the surface catching the early light, the creek 6 feet below running at its January level. He had looked at the sign on the left-hand gate post. The sign still said what it said. He left it where it was. He had taken his survey log from his jacket pocket and written the morning's entry at the gate post. January 17th, 2024. Easement recorded. Instrument confirmed. Maintenance covenant recorded. Settlement payment received. Gate open. Padlock removed. Bridge. Marsh family parcel. 1967. Access by recorded instrument effective today. Matter, recorded. A car had appeared at the bridge's eastern approach, a Crestwood Meadows resident heading out for the morning, the headlights coming across the bridge deck in the early dark, the car slowing briefly at the open gate, and then continuing through onto the western approach road without stopping. The driver had not looked at Walter standing at the gate post. The crossing had taken 5 seconds. He had watched the car reach the county road and turn. He put the survey log in his pocket and walked back to the truck. The padlock was in his other pocket. He had no further use for it. The county recorder's office had emailed the confirmed instrument numbers at 4:50 p.m. on the Monday of closing. 2 numbers, sequential. The easement assigned the first and the maintenance covenant the second, both recorded against the HOA's common area parcel in the county deed records as of that afternoon's recording session. Margaret had forwarded the confirmation to Walter at 5:03 p.m. with a single line. Both instruments recorded. File is closed. He had read the email at his desk in the ranch house, the survey log open beside the keyboard, and had written the instrument numbers in the log's margin beside the January 17th entry. He had closed the log and had set it on the desk and had looked at the window, the January evening dark outside, the ranch yard lit by the single pole light his father had installed in 1974, the light casting the same circle on the same gravel it had cast for 50 years. He had thought about his father. Harold Marsh had bought this ranch in 1951 and had worked it for 70 years. He had built the bridge in 1967 because the crossing at Sutter Creek was seasonal, passable in summer, impassable in spring runoff, and a working ranch needed a reliable crossing. He had built it himself, with a contractor and 2 hands, the concrete poured in 2 lifts over 3 weeks, the guardrails formed from salvaged pipe, because salvaged pipe was what a rancher used when he was building infrastructure for himself, rather than for an appraiser. He had written the 1994 letter because a developer had appeared and asked to use the bridge, and Harold had said yes, temporarily, with conditions, and had written the conditions down because Harold Marsh did not make arrangements without documentation. He had kept the letter for 27 years. He had kept the construction contract. He had kept the materials invoices. He had kept the hand-drawn cross-section sketch he had made before the pour. He had kept the folder and labeled it, and put it in a filing cabinet with other labeled folders, and had left it there, organized and findable, for his son. Walter had not known, when he first opened the filing cabinet in March 2021, that the bridge would become a legal dispute. He had opened the cabinet because he was a surveyor, and surveyors read the instruments before they form conclusions, and the instruments were in the cabinet, and his father had organized them so that a thorough person looking for them would find them within 10 minutes. He had found the 1967 folder in 10 minutes, and the 1994 folder the following week, and the piece of property history they represented had been legible to him immediately, because he had spent 38 years reading property history from primary documents. Harold had built the bridge. Harold had written the letter. Walter had found them both. The rest had been the law working through the documents his father had left him. He had driven to the bridge at first light on Tuesday, the January morning cold and still, the frost heavier than the previous day, the county road empty at 6:15 a.m. He had parked on the road shoulder west of the gate and had walked to the open gate on the western approach. The gate was where he had left it Monday morning, open against the right-hand post, the eye and hook latch holding it back, the drop bar resting on the post's cradle bracket, the padlock absent from the hasp. The sign on the left-hand post was unchanged. The approach road ran through the open gate to the bridge deck, the frost on the concrete showing the tire tracks of the residents who had crossed through the previous day after the gate came open. He had walked through the gate and onto the bridge deck. The deck was 40 feet long and 12 feet wide, dimensions he had surveyed to the inch in March 2021, dimensions that matched the 1967 construction contract specifications exactly, Harold having built what he had drawn and drawn what he had built. The concrete surface had the patina of a structure that had been in service for 57 years. The expansion joints cracked and resealed, the surface aggregate worn smooth by decades of vehicle crossings. The guardrail pipes rusted at their base plates, where the moisture collected at the deck joint. The deck was structurally sound. The load rating study was in the Capital Reserve Contributions scope and would be conducted in the spring. The inspector would find what Walter already knew from looking at it, a well-built concrete span that had been carrying residential traffic for 28 years, beyond its original design intent, and had done so without incident because Harold had built it to a standard that exceeded what a private ranch crossing required. He had walked to the bridge's midpoint and had stopped. The creek was 6 feet below, Sutter Creek in January, the water low and clear, running over the bedrock shelf that made this the natural crossing point, the same shelf that had told Harold in 1967 that this was where the bridge belonged. The eastern bank was visible from the midpoint, the Crestwood Meadows entry road beginning at the eastern abutment's face, the subdivision's first houses visible beyond the entry road's curve, the neighborhood quiet in the early morning. 140 households on the far side of this span. 140 families who had crossed this bridge for as long as most of them had lived in their homes, who had watched the gate go up in October and watched it lock in December, and had driven the 2-mile detour for 34 days before the easement closed. They had a legal right to cross it now, a recorded right, appurtenant to the HOA's common area parcel, running with the land, set out in an instrument that would appear in every future title search conducted on every Crestwood Meadows property from this day forward. The right their developer should have secured for them in 1994 was in the county deed records as of 4:50 p.m. the previous afternoon. He had looked at the eastern abutment, the concrete face, the date stamp Harold had pressed into the fresh concrete in 1967, the year barely legible after 57 winters, but readable to a man who was looking for it. 1967, the year Walter had turned 14, the year his father had poured this deck so the ranch had a reliable crossing, and had not known, or could not have known, that 27 years later a developer would build 140 houses on the far bank, and that the crossing would become the only way in and out of an entire neighborhood. Harold had built for the ranch. The ranch had become something his father had not planned for it to become. The bridge had carried the weight of that unplanned purpose for 28 years, and had held. He had pulled his survey log from his jacket, and had opened it to the January 17th entry, the gate opening, the padlock removal, the instrument numbers in the margin. He had uncapped his pen and had written the morning's entry below the previous one, the log resting on the bridge's guardrail pipe at the midpoint of the span his father had built. January 18th, 2024. Bridge walked. Full deck inspection. Western abutment to eastern abutment. Deck. Sound. Expansion joints serviceable. Surface wear consistent with use history. Guardrail. Surface rust at base plates, structurally intact. Eastern abutment. 1967 date stamp legible. Load rating study. Scheduled spring 2024 per Capital Reserve Agreement. Creek. Normal January flow, bedrock shelf clear. He had paused and had looked downstream, the creek running south through the willows, the water carrying the cold clarity of a January morning, the sound of it against the bedrock shelf, the same sound it had made every January of his life. He had written the final entry below the inspection notes, the pen moving in the deliberate hand of a man finishing a file he had opened in March 2021. Survey commissioned March 2021. Title confirmed. Easement recorded January 17, 2024. Maintenance covenant recorded January 17, 2024. Bridge. Marsh family parcel 44-3301-002. Constructed 1967. H. Marsh. Access. By recorded instrument. Matter. Recorded. He had capped the pen and had closed the log. A car had appeared at the eastern approach, the subdivision's first commuter of the morning, headlights on in the January dark, moving from the entry road onto the bridge deck. Walter had stepped to the guardrail to let the car pass. The driver had slowed and had looked at him, a man standing at the guardrail with a survey log in his hand at 6:30 a.m., and had continued across without stopping. The car had passed through the open gate and onto the western approach and had turned onto the county road heading south. He had watched it go. He had walked back across the deck to the western abutment and through the open gate to the approach road. He had looked at the sign on the gatepost one more time, the aluminum plate, the black text on white, his name at the bottom, W. Marsh, owner. The sign was accurate. It had been accurate since October. It would remain accurate. The easement did not change the ownership. It changed the right of access. Both things were now in the county deed records, in sequential instrument numbers, exactly as Harold's 1994 letter had said they should be. He unhooked the eye and hook latch, walked the gate closed across the approach road, and lifted the drop bar into its receiver socket. Not locked. The padlock was gone, and he had not replaced it. The gate was closed the way a ranch gate is closed when the crossing is open, but the property boundary is marked. Shut against casual passage, open by anyone with a right to open it. The distinction between public road and private land maintained without obstruction. He walked back to the truck and set the survey log on the passenger seat. The file was closed. The instruments were recorded. The bridge his father had built in 1967 had a legal right of access running with it in the county deed records, appurtenant to the HOA's common area parcel, binding on every future board and every future owner in Crestwood Meadows. Harold Marsh had written in June 1994 that permanent residential access would require a separate recorded instrument. It had taken 29 years and a locked gate, and a summary judgment ruling by a former title examiner who had read the letter the same way Harold had written it. But it was recorded. Walter started the truck and drove back to